Yes. I'm glad to see everybody here. I hope the people on Zoom can hear me. So today's subject is the separation of powers in the shadow docket. This is the first of 4 classes. The next one's going to be on citizenship. I've got most of that put together. The third one is going to be on originalism as a theory and what it says, why it's what's been behind it, and what I think is wrong with it, which is a lot. By that time, you'll be sick of me. The fourth class is going to be on, I'm trying something different. One of the main issues that we have in today's world is climate change. And what is the EPA doing about it, and what are they able to do about it under the court's rulings? And so I'm going to try and put that in legal and historical perspective. And I will start by saying I am not an environmental historian. I am a legal and intellectual historian that specializes in the late colonial and 19th century American history. And so I'm going to be learning as much as you will about environmental history. But today's subject is the separation of powers in the shadow docket. Now, last year in the 2024 term of the Supreme Court, which actually ends with the beginning of the 2025 term, which started on October 6th, the first Monday in October. And last term, the Supreme Court did not issue any blockbuster opinions like the Dobbs case that overruled Roe versus Wade. The story this past term is how the Supreme Court dealt with the government's emergency request to cancel, stay in legalese, the injunctions that grew out of the avalanche of executive orders that Trump issued after his inauguration last January 20th. Just about every one of these executive orders, what I abbreviate as EOs, every one of them has been challenged in federal district court, mostly in blue states such as California, New York, Massachusetts, and the like. And usually the challenger sought preliminary relief that would prevent the executive order from taking effect while the case worked its way through the judicial process, through discovery, trial, and appeals. In many cases, the government then sought emergency relief from the Supreme Court, seeking to cancel or stay the lower court's orders that enjoined the government's action from either you can't do something, which is injunction, or you have to do something, which is mandate. And more often than not, the Supremes gave the administration what it wanted. Each lawsuit challenged an executive order that because Trump preferred to ignore or because the order exceeded the president's authority, that Trump didn't stay in his lane, as it were. In many of these cases, the constitutional issue was whether the president's executive order violated the separation of powers that's built into the constitutional system. And that's where I'm going to begin. So please bear with me. This part of the talk is going to be a trip down memory lane for most of us. We remember, how many of us took social studies classes in school?
Nobody.
How many of you remember what you learned? I mean, I can't remember what I had for dinner last night, let alone this. But we were taught about, in those social studies classes, we were taught about our Constitution and the separation of powers that defines our national government. This is all stuff that we should know, but I think a review is necessary to appreciate the full picture of what's been happening in the Supreme Court since Trump's inauguration. So let's go back to the 18th century. How many of you remember Mr. Peabody and his boy Sherman in the Wayback Machine? Oh. That's what this is. During the French and Indian War, see how far back I'm going to go? Most colonial Americans considered themselves British patriots. That's important to know. They were proud to be part of the British Empire, to live under Britain's unwritten constitution. They believed that their government worked because it balanced the 3 primary interests. The monarch was the sovereign. In his person resided the identity of the state. But the monarch ruled in Parliament, which represented the aristocracy, the House of Lords, and everybody else, the House of Commons. Everybody else really meant second and third sons and members of the lower gentry. Only men of means and birth were deemed worthy of being members of Parliament. And the key words there are men and means and worth, birth and worth. During the 18th century, politics and political theories were the bread and butter of social education. And American colonists, as a rule, were much more literate than their European counterparts. This is just a fact of life. People read Hobbes, Locke, Montesquieu, and Rousseau. They believed that government's legitimacy was predicated on the idea of the social contract. To colonials, liberty and freedom was less about freedom to or freedom from, and much more about not being subjected to another's will or caprice. Having actual representation in the legislative body that imposed taxes and made the rules was the essence of freedom and liberty. Now, the lack of such representation in Parliament and the refusal of British elites to give it to the colonial Americans violated the social contract. Now, there's a connection here. Why did Americans believe that being subject to another's will of caprice was actually the definition of freedom and liberty? It's because they knew who wasn't free. Slaves. And American slavery permeated the colonies.
Who doesn't?
Just about every colony other than Massachusetts, by the 1770s, every colony other than Massachusetts allowed slavery.
Also, he hasn't muted people.
Now this seemed, a guy named Edmund Morgan,
He's also
Edmund Morgan, who was one of the great American historians.
Mute
He
yourself.
wrote a book in 1970, it came out in the 70s, called American Slavery, American Freedom. And this thesis, which I believe is centered to understanding the revolutionary period. And I want to read a little bit of it. This is his thesis. The seeming inconsistency, not to say hypocrisy, of slaveholders devoting themselves to freedom was not peculiar to Washington or Jefferson. The men who came together to found the independent United States, dedicated to freedom and equality, either held slaves or joined hands with those who did. Most of them had inherited their slaves and their attachment to freedom for generations. They knew that the two were not unconnected. The rise of liberty and equality in America had been accompanied by the rise of slavery. They went hand in hand. That two such seemingly contradictory developments were taking place simultaneously over a long period of time, from the 17th century to the 19th, is the central paradox of American history. The connection between American slavery and freedom is evident at many levels that we care to see. The irony is more than semantic. Americans' reliance on slave labor must be viewed in the context of the American struggle for separate and equal station among the nations of the earth. There's a lot of truth to this, because that's why Americans defined freedom was freedom from being subject to others. And if you look at the rhetoric during the Revolutionary period, it was Parliament is turning us into slaves. So that's why I just went through that exposition. During the 18th, John Adams said that the American Revolution began long before 1776, that it had built up over decades. Adams was referring to the growing maturity of colonial political institutions. That's what he was referring to. Colonials enjoyed a large measure of self-government, which they believed existed as a matter of right. By the mid-18th century, Britain's mainland American colonial governments were mostly organized alike, very similarly at the time.
Jim, there's a problem that there are a lot of people not muted on Zoom, and they're not, they're interfering with you.
Oh, thank you. I've been trying to
Somehow I can't get to the, I can't get to the menu for that.
Yeah.
Can you help me a minute, Barry?
Yeah, and if you also make me co-host, then I can be.
I'm trying to, don't know why I don't see it.
Harley, you may have to get a screen share.
What's wrong? What?
Let's see.
Oh, okay.
Oh, I can use all.
You can mute it off. Yeah. And then mine.
I am sorry, I am I'm as frustrated as you are, or as anybody is from this.
Okay.
If they can read it, that's fine. You think they're frustrated? Okay, yes, are you guys? Am I ready? Okay. I was talking about colonial governments. They were all alike. At the top was a royal governor, and he would appoint the leading men from the colony, some of them to sit on a council with him. And each colony then had an assembly, usually apportioned by district, with members chosen by property-owning adult males. While the governor or the council had veto power, as a rule, taxes and other laws came through the assembly. Britain's insistence that the home country, the parliament and the crown could bypass colonial assemblies and rule without their cooperation or consent, that's what led to the revolution. It was really a revolution over constitutional principles. Now, some historians have kind of, and Hugh Riley suggested, that our true Independence Day shouldn't be July 4th. It should be May 10th. Why? Because on May 10th, 1776, the Continental Congress passed a resolution directing each of the colonies, now states, to adopt governments independent from Britain. And in the words of the resolution, governments that, quote, would best serve the happiness and safety of the people and to America in general. Between that May of 1776 and the end of the year, 8 colonies convened conventions restructuring their governments as sovereign states. And between 1776 and 1780, colonial assemblies in the other 6 colonies did the same thing. By the way, there were really 14 colonies. We talk about 13, but Vermont is the 14th, and it was the next state after the first 13 to join the Union. And so they restructured their governments. And by the way, all of them would do it again through state constitutional conventions. The last was Rhode Island in 1842. Now, these new state governments bore similarities, and here it is. Jim, slide.
Oh, sorry.
Oops, you got the wrong one back. Thank you. No? There you go. Okay. Here it is. Britain took pride in having balanced government. And that's on the left-hand slide, the little triangle over there. You had the king at the top, you had a hereditary monarch who ruled in parliament, which represented the aristocracy and everybody else, well, sort of everybody else. But if the people were sovereign, where was the balance going to come from? Where were the checks going to be? That was the problem that was faced in designing the new state governments. And the answer was, to keep it from descending into tyranny, the answer was to separate the various powers of government and build in checks and balances. That's where it comes from. As we were taught, this assured that each institution of government, having specific powers, couldn't accumulate an excess of power that threatens the people's liberty. And so that's how you get the right-hand side. By 1787, it was clear to many colonial leaders that the loose federation under the Articles of Confederation weren't working. So a convention was called to revise the Articles. The delegates to the Constitutional Convention that sat in Philadelphia over the summer of 1787 realized that more was needed, and they produced the Constitution. The structure of the new national government was modeled on what they already knew, the state governments that had been created between 1776 and then. So the structure in the Constitution was not something that was created out of whole cloth. They knew, this was new, a bicameral legislation. They had arguments about it. By the way, I did a lecture on the whole story of the adoption of the Constitution in 2022. Is it time for me to review that? No? Okay. Enough already. In addition to separating powers between the institutions of government, power was further divided between the states, local, and national. Next slide. Now you got this one. And this is a slide that I created to show the essence of American federalism. You have the state governments that were considered, in a sense, the primary locus of the people's sovereignty, because the states came first. Now, the states delegated a number of powers to the national government, both the people and the states. It wasn't just the states. It was the people acting through conventions by ratifying that delegated power to the national government. And then states also let some of the power go downward to local governments. And so you had, what could states do? And this, by the way, explains why state constitutions are so, many of them are so big. Because states can do everything unless they've told the federal government they agreed to delegate powers to the federal government, or they agreed to cede powers down to the state and local governments. Otherwise, the only limits on state government were what was in the state constitutions. And that's why they're so long, and why they often deal with issues that have nothing to do with the structure of government. But that's another story. Okay. So this is what they came up with. This is what they came up with. And the powers delegated to the national government are in the Constitution, are in Article 1, Section 8. The powers, some of which are shared with the states and others are possessed exclusively by the national government. The overriding issue in the ratification debate over those various conventions in 1788 was whether the Constitution vested too much power in the national government. That was the issue in the ratification debates. We know how it turned out. The Constitution was ratified, in part based on Madison's promise that they would amend it to add a Declaration of Rights. And in the first sentence, Congress proposed those amendments, which were adopted as the Bill of Rights. The 10th Amendment, which is usually ignored by everybody, it's down here. The powers not delegated to the United States by the Constitution or prohibited by it to the states are reserved to the states respectively or to the people. This is kind of a reminder to tell the national government, the institutions of national government, to stay in their lane. That's basically what it is. During the ratification debates, those in favor stressed that the Constitution had built-in checks on excessive accumulations of power because of the diffusion of power between the institutions of government, and that these would check each other. Which raises the question, who is checking who? It's the fourth slide, next slide. There you go. So here's how it's supposed to work. All legislative powers herein granted shall be vested in the Congress of the United States. Article 1, Section 1. Article 1, Section 8 lists the 18 specific areas in which Congress can legislate. To keep the states in line, Article 1, Section 10 lists a bunch of things the states cannot do, such as coin money, impair the obligations of contract. Article 2, Section 1, the executive power shall be vested in the President of the United States. This idea that power is vested in the President is the basis for this theory called the unitary executive theory, which Trump adheres to, and the court is going to make decisions on, and I got more to say on that. Article 2 Section 2 of Article 2 gives the president certain powers, among which are commander-in-chief of the military, control, supervision of the executive branch. The third institution is the judiciary, Article 3, Section 1. Quote, the judicial power of the United States shall be vested in one Supreme Court and such inferior courts as Congress may establish. Article 3, Section 2 specifies the kind of cases which the national judiciary can hear. How they do so and how many judges there are is left for Congress to decide. Now, in number 78 of the Federalist Papers, Alexander Hamilton explained the checks and balances built into the structure very clearly and concisely. Quote, the executive dispenses the honors and holds the sword of the community. The legislature commands the purse and prescribes the rules by which the people are regulated. The judiciary has no influence over either the purse or the sword, only its judgment, and must depend on the executive for the efficacy of its judgments. Now, it's important to remember that the Federalist Papers represent only one side of the equation. Everybody quotes them as authority. But remember, Hamilton and Madison, who wrote the vast majority of them, I think John Jay only wrote 3 of them, were basically committed nationalists at this point. Madison would change later, and once Jefferson came home, because Jefferson was like his mentor, and he then kind of shifted and became less of a nationalist and more of a states' rights guy. But at the time the Federalist Papers were written, this is the majority. This was the winning side. And it should always remember that when you quote the Federalist Papers, is to remember that that's only one side. There was another side of anti-federalism that should be listened to as well. Now, my grade school civics classes, at least the ones that I remember, taught us to believe in this genius of divided government. Congress checks both the executive and the judiciary through the power of the purse. The Senate has the power to confirm appointments. The judges, Congress can, by statute, direct the executive to do certain things within the enumerated powers. If Congress disagrees with how the judiciary interpreted a statute, it can change it. One of the things that I remember, that when I wrote this, I was thinking about it, I have an example. I don't know if you remember, but in January of 1908, right after a Democratic Congress came in, one of the first acts they passed was called the Lilly-Ledbetter Act. Congress, the Supreme Court had ruled that in a lawsuit for discriminatory salary practices between men and women, the statute of limitations began when this discrimination first occurred. Well, that just guarantees that no case will ever be heard because people would discover the discrimination years after the fact. So one of the first laws that Congress passed, and the very first thing that Obama did after he took the oath of office on January 20th, was to sign the Lilly-Ledbetter Act, which changed the statute of limitations. So Congress can overrule the Supreme Court when it comes to statutory interpretation. Congress has the power of investigation into how the executive performs its obligation to see the laws be faithfully executed. Congress has the sole power of impeachment. Congress, by a supermajority, can override a veto. Clearly, the framers intended Congress to do a lot. Unfortunately, our Congress is now dysfunctional. I got more to say on that, too. The president checks Congress through the veto. No statute can become law without his consent unless it gets overridden. Also, the president is commander-in-chief of the National Armed Forces and administers the laws enacted by Congress. He influences the judiciary through the power of appointing judges when vacancies occurs. And the judiciary must rely on the executive in that the judges have no independent enforcement powers. As Andrew Jackson supposedly said when the Supreme Court issued a decision he didn't like, Justice Marshall has given his opinion, now let him enforce it. The judiciary's independence is supposedly assured by giving judges lifetime tenure, so Article III judges don't stand for election. Yet the judiciary is constrained by having to rely on Congress for money and on the executive for enforcement. Congress has the power to determine how many judges there are, how many courts there are, what their jurisdiction is. Judges are further constrained by the doctrine of stare decisis, the tradition that is mostly followed, and I put the word mostly in quotes, to honor their precedents. And over time, the Supreme Court has adopted the political question doctrine. It's another form of judicial restraint. The doctrine says that if an issue is not justicable because there aren't any definable standards, that then the question should be left to the political institutions, Congress and the executive, to decide. And an example of this is gerrymandering. That's why Congress applied this political question doctrine to say that how much gerrymandering is too much is not a question the courts can decide. It should be up to the political branches. Ultimately, the judiciary is checked by the people's goodwill and willingness to obey the law. And the ultimate check on Congress and the presidency lies in the people acting through elections. The entire House and a third of the Senate is up every 2 years. Presidential elections come every 4 years, and under the 22nd Amendment that was adopted in 1951, no individual president can serve more than 8 years. Now, ever since Marbury versus Madison in 1803, it's accepted that the Supreme Court has the final word on what is or isn't the law, what's allowed over the Constitution. Well, yes and no. Some people have argued that the people have a say in that too. And they do in the sense of their feet. An example is that although the fugitive slave law that Congress passed in 1850 as part of the Compromise of 1850 that allowed California to come in the Union, the people basically in a lot of the northern states ignored it. They helped slaves escape. They established the unconstitutionality of that law by simply not obeying it. So that does happen. But over time, the Supreme Court has developed some doctrines and tests to determine if either of the other branches of government have exceeded their constitutional powers. One is what they call the non-delegation doctrine. It holds that one branch of government cannot delegate to another branch those powers which the Constitution designates that it should exercise. I'll give you an example. Congress at one point passed an act in the late 1990s to give the president a line item veto because so many other states have it. In a case called Clinton versus the City of New York, the Supreme Court held that Congress couldn't do this because allowing the president to pick and choose what parts of a statute should become law was in effect the power to legislate. Now, I wonder which Article 1 reserves to Congress. You know, it's right there, first sentence of the Constitution. Legislative power is solely vested in Congress. But I wonder if it's still good law. The Supreme Court allowed Trump to sequester foreign aid money that Congress has voted. Is this essentially an after-the-fact line item veto? You know, they're going to have to decide this because that issue is going to come up. Another test the Supreme Court developed to keep federal agencies from infringing on Congress's power to legislate is what they call the major questions doctrine. It holds that where an agency decides a question of vast economic or political significance, and I put quotes around those words because that's from a case, it may do so only if Congress expressly grants the agency such authority and specifies clear standards of how and when such authority should be exercised. And I have an example of that. In the 1922 term, 2022, the Supreme Court held that the EPA violated this doctrine. What had happened is the Environmental Protection Act, the Clean Water Act, and the Clean Air Act each contain a non-specific grant of authority to the agency to, quote, regulate pollutants. But the statute doesn't say what kind of regulation they should do, nor does it even say what is or is not a pollutant. Under the statute, the EPA directed power companies to reduce carbon dioxide emissions by shifting a third of their production to solar or wind-generated electricity. In West Virginia versus the EPA, the Congress said, no, this violates the major question doctrine. There's nothing in the EPA law that specifically either defines pollutants or says what you can do to regulate them. And by basically saying that CO2 is a pollutant and that you have the power to direct the power companies to shift their production, that exceeds the authority that Congress gave in the statute. I'm going to have an awful lot more to say about this in the fourth class, because that's really what led me to schedule the fourth class, because I think that's a major question that climate change is one of the seminal issues that we have to deal with, that the world has to deal with, and it seems that dealing with it requires the government, and so this is something that's just really important. So, even given this, Congress can properly delegate some rule-making authority as long as they lay down, quote, intelligible principles to guide the delegated entity, close quote. I mean, lawyers' language is something else again. Thus, federal departments and agencies such as the Federal Drug Administration, the Federal Communications Commission, the NLRB, the EPA, et cetera, operate under an Administrative Procedure Act, which Congress provides the rules by which the federal agencies are required to follow. There are specific rules that they have with public comment and all this on their regulations. But it's full employment for lawyers. That's what, over time, there have been many notable cases holding that the president, a federal agency, or Congress exceeds the power allocated to them or delegated the power that's reserved to them. The line in the sand is not always clearly drawn. And I got examples on both sides. Back in the 1950s, the Supreme Court held that Truman, as commander-in-chief, didn't have the right to seize the steel companies because a strike was going to cut off steel production while they're fighting the Korean War. And in 2023, the court ruled that Biden couldn't, by executive order, grant across-the-board student debt forgiveness. Because the court held that that it violated the major question doctrine, and that whether or not student debt could be just canceled is something Congress, which created the student loan program, had the sole authority to decide to major changes in it, and forgiving student debt's a major change, and yet. On the other hand, the Supreme Court upheld 1970s Economic Stabilization Act, which gave the president power over wages and prices through a cost of living council. And last year, on separation of powers, They relied on separation of powers to justify giving the president immunity. Now, I think that's dead ass wrong, but what do I know? So I think you get the idea. That's basically how it's set up, the separation of powers. And I think it's almost time for a break. After the break, I'll go into how the Supreme Court conducts its business, what the emergency docket is, the so-called shadow docket, and what's up with all these cases. So, are there any questions? Yes, sir.
The 10th Amendment is so clear, as you say, powers, and yet we often hear about states' rights. And how does that?
Okay, so the question is, how does separation of powers refer to states' rights? One of the critical questions, and go back to slide number 3. One of the critical questions in states' rights is how narrowly or broadly should the delegated powers be interpreted? If they're interpreted very narrowly, then the states have more power to legislate in that area. But if they're interpreted broadly and Congress makes a rule that extends nationally, then the state can't change it. And that's how states' rights relate to separation of powers. An example of that, during the Civil War, the example was slavery. And did Congress have the power to bar slavery in the territories? It was pretty much conceived by everybody that Congress didn't have the power to tell the states that had slavery that they couldn't. But in the federal territories that weren't yet turned into states that were under the control of Congress, did Congress have the power to ban slavery in those territories? That was the issue that really, one of the critical issues that led to the Civil War, what I call irreconcilable differences between the slave and non-slave authority. Yes?
But didn't the Emancipation Proclamation then just wipe that out?
The Emancipation Proclamation didn't wipe it out because that was a war measure. The 13th Amendment wiped it out. Yes?
You mentioned that the state has a lot of power and it delegated or gave some power to the national government.
Right.
Now, when you look at the Roe versus Wade, so then the national government or Supreme Court gave it back to the states. Don't they have the power to say also, well, we don't want to accept it because it has been the law for so many years?
And California has done exactly that. California has put in its constitution that the women's right to choose is ingrained in our state law. That was California's response to the case. I'm going to talk a lot about that issue when I get to the originalism case, because one of the precepts in the originalism is that the concept of due process and equal protection are very nebulous. The constitutional issue arises in what context do they apply? Mm-hmm. And so, does a woman's right to decide during the first trimester whether to carry her pregnancy to term, is that something that she has a right to determine free of governmental interference? Yes. And if she does, then equal protection and due process prevents state, local, or national government from interfering with it. The Supreme Court has held that in those nebulous situations where rights depend on context, that they're being applied, they should only apply in those contexts which, and I'm going to quote here from memory the language in the Dobbs case, that are upheld in that are deeply held in the history and tradition of America. Well, if you think about America, and I got a lot to say about this in the third class on originalism, because when you stop and think about it, what are the major, when it comes to race relations, what's most deeply held in America? Slavery and Jim Crow lasted a whole lot longer than civil rights. How about women? The feminist movements are understanding that that gender equality is something that's demanded, is something that really arose in the 1960s.
Yeah.
You know, for most of our history, the rule was coverture. Women's identity was subsumed into that of her father, older brother, or husband. So, yeah, it's caca, but yeah, that's for another class. Yeah, yes.
I'm thinking about the relationship between power and structure. And it's sort of implicit that these three bodies, right, that they were therefore had equality of power. But how is that institutionalized and how is that mandated in the way in which they were developed?
I think it's mandated because the people who wrote the Constitution decided to do it that way. And because that was the structure that they knew. That was what they knew. I mean, Parliament had two houses. They understood this bicameralism and that having two houses meant, first off, it required agreement of both to get a law passed. Because the whole idea was we want our lawmaking to be, and I say conservative, not in the liberal conservative way, but it should be carefully selected and not, and you know, don't just pass a law, you know, what was the, what's the guy, Senior Moments, the guy that had the house that burned down in LA.
Guy Hawks.
No. Not Guy Fawkes. The guy with the rope, the lasso. Roger, not Roy Rogers, the other one. He said every time Congress wants to pass a law, they tell a joke, and every time Congress wants to tell a joke, they pass a law. Will Rogers, thank you. Senior moment. Yes, sir.
You said that on May 10th, 1776, we should be celebrating. What was the body that passed that?
It was the Second Continental Congress. The same one that voted to adopt the Declaration of Independence.
This was after the Revolutionary War.
No, 1776 was the beginning of it. Was the beginning of it.
So that started it.
Yeah, basically. It started the year before in 1775. Lexington and Concord and Bunker Hill in November and, you know, and basically kicking Gates out of Boston by putting the guns up on Dorchester Heights. But that's another story, yes. Okay, let's take a break. We're back?
We're back.
We're back, okay, so let's look at how the Supreme Court works. I think understanding how the court operates adds context to what the court's doing. And the Supreme Court is itself an institution that's developed procedures given to process the amount of work they're called upon to do. And so let's talk about just how they do it. And I'm going to start with the fact that each justice, there's 9 of them, set by Congress. Last time they changed it was in the late 1860s or early 1870s. Each justice has an administrative assistant or office manager and 4 research clerks who are young lawyers who serve for a year and occasionally 2. And by the way, they only serve that long because, as Justice Jackson, who was clerk for Justice Breyer, said that when you are a law clerk, it's a 7-day-a-week, 18 to 20 hour a day job. And at the end of a year, you are totally burned out. And that's why most of them only serve a year or 2 at the most. Other than rare matters within the Supreme Court's original jurisdiction, the Supreme Court is a reviewing court that hears cases that come from lower courts, and it decides what cases it wants to formally hear by granting what's called a petition for a writ of certiorari. Cert, as I'm going to say from now on, because I can't pronounce certiorari. If they deny it, that's it. The lower court decision stands. If they grant it, which happens maybe 90 times a year, out of over 3,000 to 5,000 such petitions that are filed every year, the court defines the issue that it will address. The parties are given a briefing schedule and the case is set for argument. They hear arguments during this annual term, which begins on the first Monday in October and ends on the last working day in June. Except during the summer recesses, The justices meet weekly in conference to decide the cases that were argued that week and all the other matters that come before the court. And I'm going to talk about the other matters in a minute. At these conferences, the Chief Justice is first among equals in that he chairs the conference, he leads the discussion, but he only has one vote. When the majority in the Supreme Court makes a decision that they go around the table and they vote, they discuss and then vote, each judge is asked to what he thinks. So the Chief Justice gives his opinion first, then it goes around the table. So each justice has a time to say what he says. They then vote, and then if the Chief Justice is in the majority, he will assign either to himself or to one of the other justices in the majority to write a majority opinion. If the Chief Justice is in the minority, the senior justice, the guy who's been there, the person who's been there the longest, gets to assign the opinion. And draft opinions are then circulated among the justices internally, which we never see. That's why it takes, a case may be argued in December, but you don't find out what happened until the following May or June. That's because during that period of time, they're circulating opinions. And they're negotiating because they got to get at least 5 justices to, well, I don't like this part of the opinion. Why don't you say this? And another justice says that. And they have to negotiate these issues so that when the opinions are announced, that's how they come out. Now, and then when they're finally in final form, the decision's announced from the bench and the various written opinions are released to the public. That's how it works on those cases, those 90 or so cases they formally hear every year. Although the court's in session only during its term, it's open year round. Each year, and usually they start in August, each year, the 36 research clerks divide up all the applications for certiorari that come in over the summer and prepare a memo on each case that summarizes the issues, the factual and legal issues, and the extent that it meets a sort of an unofficial criteria for selection. How important is it? Does it resolve a conflict within the various circuit courts? In other words, does the Ninth Circuit disagree with the Fifth Circuit on some important issue, in which case the Supreme Court has to decide? And usually the week before the term starts, the justices hold what they call the long conference. And in this conference, they get all these petition memos of all the certiorari petitions that come in during the year. And where they do deal with this backlog. And it's usually about 2,000 or 3,000. This long conference has been called by some, quote, the place where petitions go to die. And that's because the cases that the clerks think worthy of discussion go on a discuss list. And each judge can add cases to the discuss list. No one judge can take a case off of the list, but any judge can add a case to the discuss list. For all those petitions that are not on the discuss list, they're denied without any formal vote, without any further vote or anything else. If it doesn't make the discuss list, they're automatically denied. It's kind of like when you served on an academic committee and you're looking at who's going to be admitted to school, and you have a let's talk about file, and you have a no file. And the no file goes like this, and the let's talk file is like this. That's like the discuss list. It's basically the same thing. And this year's long conference was held on September 29th, and on October 6th, the Supreme Court released some 950 orders denying cert, and then more every day. Although the court receives routine motions relating the cases set for argument, they get permission to modify the briefing schedule, or someone wants to file a brief in a case, what's called an amicus brief. I'm not a party to this case, but I'm really interested how it turns out. Can I file a brief? You got to file a motion to the Supreme Court to do this. All this stuff are routine motions that are dealt with in the conference, and they're dealt with by brief unsigned orders that grant or deny the request. And generally, if 5 judges want to go a certain way, that's the order. Which leaves the emergency docket. It's also called the interim relief docket, also called the shadow docket. These are cases where a party files a request for the Supreme Court to issue an order on an emergency basis that relates to a case that's pending in the lower courts. Except in unusual cases, the court usually decides these requests without full briefing or oral argument. The requests fall into 3 general types. The first and most common historically is relief from stay of execution in death penalty cases. And this was traditionally what 90% of these kind of requests were. They would go to a judge, and depending on where the request is located, because each judge is assigned to supervise one or more districts. And so if a case goes to the 5th district, maybe Justice Thomas, and he will then refer, he can either decide it or refer it to the full court. Another is what's called emergency applications, where one justice denies a request and the issue is presented to another justice. It's like a kid asking the father for permission after mom says no. And usually these applications are during their weekly conferences are routinely denied unless 5 justices believe it should have been gone to the whole court. Most often than not, these emergency cases are referred, especially in major issues, are referred to the full court. If they're clear, if it's something that's absolutely clear, and not really that important, like relief from stay in a non-death penalty case, they'll let the judge decide it, and it won't come up. But because the justices strongly disapprove of judge shopping. Then there are the requests for emergency relief from lower court orders that grant or deny requests for injunctions. Injunction, remember, is what you can't do. Mandate is what you have to do. When the government's a party, the cases usually involve administrative agency disputes, First Amendment conflicts over speech or religion, presidential executive orders, or statutory enforcement. And the legal issues vary. Sometimes it's procedural. Did the plaintiff have standing to sue? Was the case brought in the correct court? Did the federal court have jurisdiction? Other times, the main issue is balancing the equities. You know, what party gets hurt the most? Who gets hurt the most if the relief is granted or denied? And sometimes the issues go down to the heart of the case. Was a statute, agency regulation, or an executive order unconstitutional or otherwise unenforceable? Applications for certiorari, routine motions relating to pending cases, and these shadow docket cases are normally decided per curiam. That means by the court, without attribution of authorship. All justices are deemed to concur in the order unless a justice decides to make his or her preference known. More often than not, per curiam orders do not reveal the reasons behind the decision, and sometimes the only hint to that reasoning is if a justice files a dissenting opinion saying why they disagree with the order, and then you get a sense of what the legal issue is, or a judge who went along with it files a concurring opinion that he wants to explain why he voted the way he did. And sometimes that's the only way you know what the legal issues, what drove the decision to come out. Which brings me finally to what's with all these cases over Trump's executive orders. Now, since January 20th, Trump has issued a plethora, you all know what that word means, of executive orders that have fundamentally altered the way things have been done, whether from the left or the right. And whenever there's major changes, and whichever side they come from, some people love it, some people hate it, and someone always gets hurt. And Since mid-December, there have been over 300, as of mid-September, there were over 300 pending cases against actions being implemented or threatened to be implemented based on Trump's policies, with more that are seemingly filed every time he opens his mouth. In fact, just yesterday, and this came out just yesterday, Trump's Department of Justice filed a 35-page motion to set aside an injunction that prohibited federalizing the National Guard in Chicago. Now, they allege that it was necessary to keep the peace because they're interfering with the federal government's with federal officers' duties, and local governments unable to deal with it. Now, if the Supreme Court accepts the government's descriptions of the demonstrations against ICE, et cetera, then they might win. But if they accept the district court's finding that it was unnecessary because local government can handle this, it's not necessary to National Guard, then they might lose. I'm not going to venture a formal opinion as to which way I think the court's going to go. But this is the kind of stuff that's happening every day. So these cases challenging the government's actual or threatened actions, and they fall into several categories. A lot of them relate to immigration and ICE, including cancellation of paroles, mass deportations, immigrants being deported to countries other than where they came from, enforcement strategies and tactics, including how ICE agents go about their business, what constitutes probable cause to detain someone if he's possibly if he might not have legal status. Other cases concerns Trump's attack on birthright citizenship, and I got a whole class on that next week, so I'm not going to say anything more about it. A number of cases challenge both mass layoffs as Trump tries to drastically shrink the size of the federal government, and others involve his firing specific federal officials, some without cause, contrary to statutory language. Some cases involve canceling grants or withholding grant monies to third parties under foreign aid, National Institute of Health grants, grants to universities, and other congressionally established programs. Trump also threatens to withhold federal funds allocated by law to a number of states that have or permit local governments to have so-called sanctuary laws. In two cases, challenges unilaterally imposed tariffs on just about anything from everywhere. And you have the National Guard cases. A common thread running through all these cases is whether Trump exceeds his authority under the law or the Constitution. That's why I spent that whole time, the first half of the class, talking about separation of powers. Some involve the degree that Congress can limit the president's authority over an agency's directors. Can Congress specify that such officials can only be fired for cause then at the president's will? As to tariffs, Trump relied on general language in statutes as to authority, and cases question the legality of that reliance to impose tariffs, similar to the reliance of the EPA on general language in the Clean Water Act to regulate CO2 emissions. Now, the avalanche of these cases is of recent origin. Where national injunctions are concerned, and I'll got more on this next week, there were relatively few during the 16 years of the George W. Bush or the Obama administrations. During Trump's first term, 85 nationwide preliminary injunctions were issued by lower courts, 28 during Biden's years in office, and so far this year, 35. Just from his inauguration until this last June. Now, the Guardian sorted these cases involving by type and state. Slide. And here's their next slide. There we go. This kind of breaks the Guardian sorted them by state and type. You notice they're all over the place. The majority were filed in blue states where the challenges seem to be more receptive. And very few in states that basically are where the judiciary, the federal judiciary, are mostly Trump MAGA supporters. Many, if not most of the times, the government seeks an emergency order from the Supreme Court to stay the injunctions and allow the governmental policies to go into effect. That's what this is about. The New York Times broke down how justices voted on these per curiam decisions. Next slide. And you'll see that this partisanship isn't new. This just tells you how it's gone.
Wow. Thomas. Expect that. Yeah.
So there are the four originalists. Alito, Gorsuch.
Well, the originalists, there's 6 of them. The strongest ones are Alito and Thomas, and that's the lunatic fringe. But then there's Roberts, Gorsuch, Kavanaugh, and Barrett. But I'll tell you, Gorsuch is an interesting case. His mother was Reagan's Secretary of Education. And Reagan, Congress kept shutting her down whenever she tried to do anything, because she's also very, very kind of far right. So Gorsuch has a thing about federal agencies. Just right there. He doesn't like them. And Roberts is basically, you're talking about guys who clerked for Scalia and Thomas. That's their background. Okay. This partisanship isn't new. It's been marked the Supreme Court. You can remember the Obama State of the Union address in 2010, where he chastised the Supreme Court over the Citizens United case, and Alito said, that's not so. Recent decisions on the emergency docket reveal that sometimes 6 justices support many of Trump's initiatives. As Justice Barrett admitted in a recent interview with Ross Duho of the New York Times, how many of you have seen that interview or read it? It's a very lengthy interview. Ross Douthat, is that how pronounce his name? D-O-U-T-H-A-T. That's how it's spelled, Douthat. He and Barrett share a lot in life. They're both Catholic, they both have large families, they're both conservative, but Douthat is no Trump lover. He's not, if you read his editorials, he reminds me of George Will in that sense. But she favors, and she says that most of the conservatives on the court favor the unitary executive, which allows the president wide latitude over the executive branch. And by this view, any constraints on the president's authority should be narrowly implied. Their reasoning is that the Constitution vests vests the authority to run the executive department in a president. That's the language. The executive authority is vested in the president. That's how Article 2 begins. And I'll give you the exact language here. I got this when I was in law school, so it's pretty old. The executive power shall be vested in the President of the United States of America. And the conservative majority in the court believes this means that he's got the authority to run the executive department. Because he's responsible for it, which includes enforcing the law, the president's authority should include being able to fire federal officials who have discretion over how policies are applied by the various agencies. In Trump versus Wilcox, and another case, that on the emergency docket, the Supreme Court ruled that discharged members of the National Labor Relations Board and the Merit Systems Protection Board, whose appointments were confirmed by the Senate, stay fired while their cases are pending. Even though there are statutes that establish these agencies, said that the directors board of the agencies, during their terms of office, they should serve for a set term of years, appointed by the president, confirmed by the Senate, and they should only be fired for cause. Now, for cause has a legal meaning. Usually it's wrongdoing while in office. Remember that. In a similar matter, on September 22nd of this year, past year, in Trump versus Slaughter, the Supreme Court stayed an injunction against Trump's firing Ms. Slaughter, who was a senior member. She was on the Federal Trade Commission's board, and he fired her without cause, even though the statute creating the Federal Trade Commission specified that its senior members could only be fired for cause, wrongdoing while in office. The Supreme Court treated the government's motion as a petition for certiorari and stay, granted the stay, and set the matter for oral argument. The Supreme Court identified two issues it was to decide. First, whether statutory removal protections for members of the Federal Trade Commission violate separation of powers, and whether a case called Humphrey's Executor versus United States in 1935, that case unanimously held that a person, the head of the FTC, cannot be fired except for cause, and said that that did not violate the separation of powers. And they also said the second issue was whether the federal court has jurisdiction to prevent such persons from removal from public office while the case is pending. In other words, does the federal court even have jurisdiction over the right to say the president did something wrong? In other words, the president, and if they're right there, then the president might not be able to do it, but no court can tell him he can't do it, which is kind of a now you see it, now you don't kind of thing. The Supreme Court's order had to have at least 5 votes to be made under the emergency docket, which tells me that a majority of justices are prepared to rule in Trump's favor. Justice Kagan's dissent, joined by Sotomayor and Jackson, is short and to the point. I want to read you part of it. It's, for a dissent, usually these dissents are really long. This one's short. She said, I dissented from the majority's prior stay orders and do so again. She stayed in the NLRB and the Merit Protection Board cases. She dissented. Under existing law, what Congress said goes, as this court unanimously decided nearly a century ago. In Humphrey's Executor versus United States, we rejected a claim of presidential prerogative identical to the one made in this case. Indeed, the suit emerged from a discharge at the same agency. Congress, we held, may restrict the president's power to remove members of the FTC, as well as other agencies performing quasi-legislative or quasi-judicial functions without violating the Constitution. So the president cannot, as he conceivably did here, fire an FTC commissioner without any reason. To reach a different result requires reversing the rule in Humphreys. Now, the majority may be raring to take action, as its grant of certiorari suggests. But until it's done, Humphreys controls and prevents the majority from giving the president the unlimited removal power that Congress denied him. Because the majority stay does just that, I dissent. Our emergency docket should never be used, as it has been in this year, to permit what our own precedent bars. Still more, it should not be used, as it has been, to transfer governmental authority from Congress to the president and thus reshape the nation's separation of powers. I thought you enjoyed reading that. I call this is the congregation of the convinced. Trump has also attempted to fire Loretta Cook, who Biden had appointed in the Senate, confirmed to the Federal Reserve Board. Under statutory law, such members could not be fired except for cause. Trump said that he had cause. Why? Because long before her appointment, she allegedly committed mortgage fraud. What did she do? She claimed on a loan application that her second home was her principal residence. When Cook sued, the district court didn't buy Trump's argument. The court said that cause means that it didn't buy his idea of cause. Cause means misconduct occurring in office, and therefore she ordered that she stays. Now, in this case, it's interesting. Justice Kavanaugh, in the Wilcox case, had filed a concurring opinion. That was the one that it was okay to fire a member of the NLRB, even though it said she could cause. But Kavanaugh said that the Federal Reserve Board is different. Unlike the NLRB or the Merit Services Protection Board, it's not part of the executive branch. It's an independent agency that Congress has established, independent of both the president branch and Congress. And therefore, it didn't apply. Interesting, the Supreme Court did not stay the injunction. And Ms. Cook remains on the board. But it's scheduled oral arguments because on the judgment's request this coming January. I think Trump might lose this one. But it's a minor loss. It allows him to feel good about ruling in his favor on all the other bullshit. Pardon me, that's a legal term. I was once in a deposition where a lawyer accused another lawyer of using chicken S tactic, and I said, please, there's no reason to use defamatory language in this deposition. And he said, when it comes to Mr. So-and-so, that is not defamatory. Okay, and I would say that with respect to Trump, that's the same thing. The Supreme Court granted the emergency, okay, so I think Trump's loses. All right, there's some other cases I want to mention. The Supreme Court granted the emergency request and stayed the lower court injunctions in all those mass downsizing cases. Remember, the DOJ did. The case is called Trump versus American Federation of Government Employees, and a second case, McMahon versus New York. So all the people that were laid off by the Department of Education and the other agencies under the DOJ directives stay fired while their cases work their way through the courts. In another matter, the Supreme Court set aside a lower court order that the government couldn't kick transgender people out of the military. Why? Because Trump, as commander-in-chief, has the power to set and enforce those policies. He has had his way in immigration cases with only two minor exceptions. The exceptions are that a citizen who was deported in error had to be returned. That was that guy, Caesar, whatever his name is. And due process requires that immigrants must be given notice with time to object when the government intends to deport them. Otherwise, the Trump administration has been given a free hand on immigration matters. ICE is allowed to rely on ethnicity, language, and employment in deciding who to temporarily detain. The protection for Venezuelans has been canceled, and a bunch of other things. Further, the Supreme Court has given the administration the benefit of the doubt when it comes to withholding money under programs authorized by Congress while the cases work their way through. The Supreme Court's conservative majority dissolved several injunctions because the grantees of canceled grants who had done the work sued in district court when under applicable statutes they should have filed in the Court of Claims, which is a separate court system that was set up to handle monetary claims against the United States. Why did they sue in the wrong court? You say, well, the lawyers screwed up. The Court of Claims does not have the power under its grant to grant emergency injunctive relief. So they sued in district court, and all they asked for was injunctive relief while they sued in claims court. The Supreme Court basically said, no, they can't. That one doesn't last. Interesting, the three liberals, Kagan, Sotomayor, and Jackson, were joined by Roberts and Barrett to say that the government can't decide these cases strictly on whether or not the grantees toed Trump's line on policy relating to DEI matters. But that was a Pyrrhic victory, because on September 26th, the Supreme Court, by one of these emergency orders, allowed the government to withhold dispersing $4 billion in foreign aid. Kagan, as joined by Sotomayor and Jackson, dissented. Kagan argued that impounding money appropriated by Congress effectively allows the president to usurp the power of the purse. It also allowed the president to do an end run around the ban on line item vetoes that the Supreme Court had held unconstitutional in the Clinton versus New York case. And she also took issues with the majority deciding this momentous issue, quote, on a short fuse without briefing, oral argument, and opportunity to deliberate in conference, close quote. So what about the tariffs? Let's talk about the tariffs. They've been put on hold by some of the courts. Some of them have been put on hold. Others have been delayed by Trump himself. Seems like every day he puts one on, takes it off, puts it on, and takes it off. And some are in effect. I tried to figure out which tariffs are in effect and which are not, and I gave up. I'm sorry, folks, I just couldn't take the time. It wasn't worth it. The government has asked for an order allowing the state tariffs to go into effect while the cases are pending. And rather than rule on them per curiam, the Supreme Court took the unusual step of granting cert on both. One case is called Learning Resources versus Trump, and the other is called Trump versus VOS Services. You'll see those names in the paper. They're set for argument this coming November 5th. Trump contends that the nation is under a number of threats, and the tariffs are authorized by, and I'm following me here, the International Emergency Economic Powers Act, IEEPA, that was passed in 1977, which allows the president to, quote, deal with any unusual or extraordinary threat to the national security, foreign policy, or economy of the United States, close quote. However, this act does not mention tariffs. In each case, the lower courts found that imposing tariffs based on this act were beyond the president's power. As the circuit court for the DC district stated in its majority opinion, upholding an injunction, quote, when Congress intends to delegate to the president authority to impose tariffs, it does so explicitly, either by using unequivocal terms like tariff or duty, or via an overall structure that makes clear that Congress is referring to tariffs, close quote. I think that the orders that granted cert in this case hint that Trump's unilateral imposition of tariffs may be on shaky ground. The Supreme Court defined the issue, and I got a copy of the orders in the two cases here. In one of them, the court issues it says, whether the EPA, the IEEPA, authorized the president to impose tariffs. And it says in the order, up till now, no president in the IEEPA's nearly 50-year history has ever invoked it to impose tariffs, let alone the sweeping worldwide tariffs imposed pursuant to the executive orders challenged here. Now, to get this language in the order, 5 justices had to agree to it. So that may give us a hint as to which way the court's thinking. In the other case, the court not only said, does the IEEPA authorize tariffs, it also said, if it does authorize tariffs, does the statute unconstitutionally delegate legislative authority to the president? Again, by defining these issues this way, I think there's a pretty good argument that the Trump may lose this one. And I think, I've always felt, and I know this is for years as practicing law, that if you define the agenda, you kind of have a leg up in controlling the outcome. And so it's important to hear and look at how the court will define an issue that it's going to decide. Because the order that's issued defining the issue, if it's only just straight cert and not involved in an initial order, that order has at least 4 judges agreeing to the language in the order. If it's an order that deals with an emergency, something on this shadow docket, that order has to have 5 votes. So that gives you a pretty good idea which way it's going to go. So I want to give a little recap here. Per curiam decisions to either suspend or leave in place preliminary injunctions or mandates while the case is pending are not intended to be final dispositions of the underlying case, but many times they are. Cases can take years to process with discovery, deposition, trials, and appeals. Many of the preliminary rulings from the emergency docket will be just as final as an order denying relief from stay in the death penalty cases. Because individual immigrants may not be around to prosecute their case if they're already deported. Budget years ended and money can only be spent during the time the expenditure has been authorized. Individual grant claimants may be out of business or unable to institute another round of litigation in the Court of Claims. Terminated federal employees find other jobs, and they've moved on. Parties or their lawyers may give up, and litigants run out of money. All these kind of reasons, every lawyer knows this happens. Cases don't always last. And so these temporary orders may end up, although they're not intended to be permanent. And a lot of the justices say, well, this isn't permanent. You know, we haven't decided how we're going to rule. This is only a tentative while it's pending. It could very well be the only word we'll have on these issues. And to hold it, to do it on the emergency docket is, in my opinion, just it verges on the whatever. I'd say criminal, but the Supreme Court, you know, they're not capable of committing a crime because they're perfect. What is apparent is that right now, 6 justices on the court are making their predilections obvious. And Trump has won far more than he's lost. In most of these cases, the justice decisions responded to 2 main questions. How much deference should be given the president regarding executive powers? And the second question is, how much harm to the government if its intended actions cannot take effect while the underlying case works its way through the courts? And I'm saying in both questions, the majority of Supreme Justices have clearly answered a lot. Now, I went over this stuff with my daughter the other day. She asked me questions about what I was doing. And she wants me to send her my notes, which I do. And she started crying. And I realized why. Our constitutional structures are designed with certain assumptions. One of them is that presidents will be leery of exercising executive power over the military and National Guard for blatantly political purposes, to silence critics, to properly, and that they're going to properly, to silence critics who are exercising their rights, and to peacefully protest and speak out. And it assumes that when presidents exceed such powers, either Congress, by enacting remedial statutes, or the political process, or getting funding, or the court, somebody's going to do something about it. That's kind of an assumption. But those norms have changed. Trump has basically blown out all these norms. In our present situation, we have an inept Congress controlled by the president's allies. Right now, it's not willing to do anything. The House isn't even in session. And the Supreme Court's unwilling to tell the president that his actions are blatantly political and they got to stop. So I think the only solution is we, the people, have to act. No King's marches shouldn't be once a month or once every other month. They should be every week. They should be weekly, especially in the cities where the president is currently centering his activities. And the people have to turn out. We must vote, and we must diligently act to assure that voting is open and fair where it's threatened by the president's political allies. Ultimately, right now, people say, what can we do? That's it. Questions? Yes, sir.
You talk about voting, but the way the states have been reapportioning voters, are we going to have a fair election anymore?
Well, it depends on how you define fair. I can't answer that question. The ultimate answer is the Supreme Court has decided a number of cases. They got another one that they're going to decide this coming term out of Louisiana. And my feeling is they're going to throw out the map. And they're going to basically say reapportionment is a political issue. It's covered by the political question doctrine. And the states, under our Constitution, the only constitutional mandate is that they have to be of equal size. And where they're mandated, where they're divided up based on political history, it's an open question. I'm debating, the only way to fix it would be to make Congress, where they be, or a constitutional amendment, to make it illegal for states to use past voting practices in any way in deciding how to draw districts. But I doubt whether even that statute would be held constitutional based on the fact that it really goes far beyond what's the language in the Constitution. It may require a constitutional amendment to do something about it. What is the possibility of there being a constitutional amendment? Between zero and none. Because think about it. Who gets under the present system, who gets the power? The small states have the power. Has anybody with power ever voted to voluntarily give it up? That's my answer. Yes, Gunther.
A question, just more philosophical. You think that that the Supreme Court takes a balcony view on their behavior and what they're doing and how they are making a significant change? I mean, it just.
First off, they're going to argue that they're not making significant changes. They're just going back to all these significant changes that were made during the war in 12 years. Then we're going back to the way the government's always been. Because when you stop and think about it, if you look at the breadth of American history, the only time we had a truly liberal Supreme Court was from 1937 to about 1975. Otherwise, the Supreme Court's essentially been conservative. Because who are judges? Judges are generally, they're basically dead white guys. That's who they've been. And there's a natural, so philosophically,
So you're saying just for 40 years, 37 to, we'll call it 77.
we had a Supreme Court, we were on the way, you're taking this is what I'm going to talk about when I get to originalism. Because the point is that for that 40-year period, the liberals had a hell of a winning streak. And now they're taking it away from us and we're all pissed. Gunther, you had a question.
Yeah, the Supreme Court overturned Lennon versus Kurzweil and rejected church-state separation. Can you elaborate on that?
Elaborate on the Supreme Court.
Well, I always thought that in the Constitution is separation.
There's nothing in the Constitution about separation of church and state.
There shouldn't be an
The Constitution says two things about religion, and I'll read it to you. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. Now, the whole idea of separation of church and state was in a letter that Thomas Jefferson wrote in about 1800 something to some Danbury community. And he said that in this letter that the First Amendment is designed to guarantee that there shall be a wall of separation between the government and religious activity. Because in Jefferson's notes on the state of Virginia, he noted that historically, all these religious wars came about because people fought over doctrine. And the best way to stop religious wars is to not do anything about it, to not care. Now, but the problem that you have is that the Establishment Clause and the Free Exercise Clause can come into conflict when the free exercise is by a person in government holding a governmental position and saying that I want to free exercise my religion, and if I have to follow this policy, it's against my religion. So do I have to follow the policy? And so the issue is whether or not the Free Exercise Clause trumps the Establishment Clause where it comes to a governmental official. That's the issue. And this court is conservative. So that's what I have to say about it. Yes.
What words of hope did you give your daughter?
Go out and march.
Yeah.
That's it. Trust the people. And I do. I'm an optimist. I'm 83. I figure we've lived through all this. We lived through the Civil Rights Movement. We lived through World War II. We've lived through Vietnam. I'm still here. And so I'm an optimist. And so that's where I come from. Yes, you.
Okay. not that I would want to reverse the Cook decision, but the Federal Reserve was established by Woodrow Wilson, and you said it's not considered part of the executive. How is that determined?
Congress, when they passed the law, set it up to be an independent agency, not subject to the president's control. And you'd have to look at the language in the statute. And it would be the language in the enabling statute that would determine whether or not, because the president can appoint the people who are going to control the Senate, but it was intended to operate independently of the executive branch, to regulate the financial markets in the United States. That the president does not have the authority under Article 2 to regulate the economy. Congress has the authority to regulate commerce among foreign nations and among the several states and with the Indian tribe. So therefore, the Federal Reserve Board, which is in effect regulating financial matters, is under the necessary and proper clause that affects the Congress clause. That's the constitutional idea of the constitutional authority for it. Yes?
How does opposition groups like newspapers, universities, Jimmy Kimmel, whoever, how do they challenge the president, especially universities and the press?
Through public action, through editorials, through writing, through putting the word out, through public action. There is no legal action. They can file a lawsuit, but then when they file a lawsuit, they're not in their home court. They're in the judiciary's home court, and their claims are going to be subject to the judiciary rules and policies. So it's the people. Yeah, basically it's public relations, Constantine.
I submit that you're saying that the Federal Reserve changed the gal that was indicted, fired for cause.
Yeah.
That's not a picayune issue. That was on purpose, I think.
Well, it was, because that's why Trump.
That's in his favor.
Yeah, what happened is Trump was sued in New York
Right.
for bank fraud,
Right.
for defrauding banks based on gross exaggerations of value of its property.
Right.
What?
You're talking about Letitia James?
Yeah,
Yeah, right.
Letitia, who was the head VA,
Not Cook.
right, but Letitia James brought a lawsuit against Trump. Trump was found guilty of a number of criminal offenses under New York's law. So he's pissed.
Yeah.
So he's going after Loretta Cook, saying she did the same thing that I was convicted of a crime for. I can fire her. Because she told some bank that was giving her a loan on her vacation house that it was going to be her principal place of business, or a house she was buying for a relative. Roger.
But I'm submitting that that's not chicken shit, so to speak.
Well,
It's on purpose.
well, he's acting on purpose, but it's a chicken shit.
Oh, I see.
You phrased a lot of this in terms of conservatives' ideas opposed to other ideas. But what about corruption? I mean, when one of these people flies the MAGA flag and another one takes huge gifts from people who have cases pending before the Supreme Court, isn't there a corruption going on here that's affecting all these things?
I think there is a corruption, but the remedy for corruption is impeachment. And impeachment lies in the House of Representatives, and if there's a trial in the Senate. Only one Supreme Court justice has ever been impeached, and that was a guy named Samuel Chase, and it was right after Jefferson became president, shortly after 1800, because he was a Federalist and had always ruled against the Jeffersonian side, and he was also a very irascible person, and he basically insulted anybody who disagreed with him, and would tell him, you have the mind of a flea, and more language even stronger than that. And he was impeached by the House, and the Senate did not convict him. And that is the only time a Supreme Court justice has ever been impeached. But the only remedy for removing a Supreme Court justice would be impeachment. And what is the chances of that happening?
0 or not.
Yeah, maybe, hopefully, yeah.
So, you were talking about circulating and negotiating. Do we have any evidence of a civility or a lack thereof between the Supreme Court justices?
I don't know. There's some appears, and there's some civility that you get hints to. Usually a dissent will say, I respectfully dissent. If the word respectfully is left out, you know that there's something going on. And that's been true in a number of dissents, especially filed by Jackson. And some of Thomas's language dissenting in earlier cases veered on that too. And so, there's hints. But these conferences they have, they're closed. And not even staff is allowed in there. The junior justice opens and closes the door. When their lunch is delivered, there's a knock on the door is open, the food comes in, and it goes out. And nobody says a word while that person is reeling the tray in. So we don't know. There's only hints that we can have. And none of the judges are going to go online and saying, so-and-so's an asshole. It's not going to happen.
Question?
Yes.
So Obama appointed Merrick Garland to the Supreme Court.
No, he named
Well,
Merrick.
he named him.
He said, I'm sending his name to the Senate as a nominee.
And they have the power to approve or reject,
And they also have the power to calendar it for a vote.
and they did nothing.
Right,
So couldn't have Obama, so since they did nothing, couldn't Obama interpret that as an approval?
No. No, because.
English common law might.
No, because the only thing you can interpret is if a law is passed and and while this Congress is in session, the president neither approves it nor disapproves it for 10 business days, then the law is deemed passed. So the idea that the president could not just put it in his pocket and that would be effect without going on record as to whether it's a law. However, if Congress adjourns before that days is up, then the law is deemed vetoed. That's called a pocket veto. So the answer to your question is that because there's no law, there's nothing that Congress passed or enacted that was there for Obama to either approve or disapprove. What it was the Senate Majority Leader refused to schedule hearings on whether or a vote on that nomination. And because each house is entitled to make its own rules, and that's right in the Constitution.
So that's interpreted as a no, a rejection.
It's interpreted as it never comes to a vote.
Right.
And the nomination dies when Obama's term of office ends.
Silence normally would be in agreement.
But no, Jim, you're oversimplifying. And don't oversimplify. That idea that silence only means agreement exists when A, there's a law that's affirmatively been passed, we vote yes on something, and the president does nothing about it and while Congress remains in session for a specific period of time. That's the only time when not doing anything means yes. Any other questions? Thank you all. Let's go have lunch. See you next week. The House can make its own rules, and under the House rules, the Speaker decides